Very warm good evening to all. Today's topic is about a woman's very sensitive issue, that is about the pregnancy and the miscarriage. If it happens, it is the worst thing happens to any woman. As a woman, I and all the women here will understand that the pregnancy is something which is in our country is good news. This good news is like bringing happiness to the complete family, but this is not true always. We are telling we are progressing and we are becoming a modern society now. But we do see that with technology, we have tried to even sometime kill the female fetus in the womb itself. That we before she is given birth, she is killed in her womb. It is so the injury or the harassment or what we call is like cruelty to the woman starts from her womb. Now, when we are doing this, actually, it is the, if we call it religiously, it is the biggest sin. There are some religions which says that killing the child in the womb, fetus, it is not even the child, it is fetus. Killing the child, killing the fetus in the womb is the biggest sin. And there are many countries which do not allow the abortion. And these are foreign countries, not our country, but some are the foreign countries which do not allow. There are religions which say that it is a sin. Now, keeping everything, all this aside also, a woman who is going to give birth, and if she is not supported, and she is asked forced to go for abortion, then this is a crime under the Indian Penal Code. Say Indian Penal Code have two important sections, 312 and 313 of the Indian Penal Code. Now these both sections are, I would say, the punishment is equivalent to almost the murder of the fetus is the murder of the living person. Let's go to the section 312 and 313. Let me share. We will read the proper the definition given in the law. This section 312, causing miscarriage. Whoever voluntarily causes a woman with child to miscarry shall, if such miscarriage be not caused in good faith for the purpose of saving the life of the woman, there are some, this is an exception, be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. And if the woman be quick with the child, that is the child, actually we say that after 4 months, the child start giving some movements in the womb, shall be punished with imprisonment of either discretion for a term which may extend to 7 years, and shall also be liable to fine. Now here there is an explanation. A woman who causes herself to miscarry is within the meaning of this section. This the explanation means the woman who is also a party, who is pregnant, who is also a party, and goes for the for miscarriage, for the abortion. See, the word is not used the abortion. It is a miscarriage. The word used is miscarriage. There is a reason behind it, because miscarriage is something which we, the abortion is different in the medical term, and miscarriage is different thing. Now here the woman who goes for the for aborting the fetus also will be having the punishment, will be punished for this. Now woman who causes husband to miscarry is within, so this woman is also included, the pregnant woman. Here the one word is used that who is a quick with the child. Now quick with the child we will try to understand with one judgment which will follow this. Now, another section is devoted in Indian Penal Code is causing miscarriage without woman's consent. Whoever commits the offense. Now, the previous one was maybe the woman herself and maybe with her consent. Now, causing miscarriage without woman's consent. Now, whoever commits the offense defined in the last preceding section without the consent of the woman, whether the woman is quick with child or not, whether she's quick, she may be pregnant for 2 months, 3 months, or that is below 4 months, or not, shall be punished with imprisonment for life. See the punishment, shall be punished with imprisonment for life. or with imprisonment or either description for a term which may extend to 10 years and shall also be liable to fine. So section 313 is very serious here. Now we will try to understand this both sections with the help of one judgment, that is Imtiaz Ismail Sheikh versus State of Gujarat. Now in this judgment, just a minute. I would like to here mention about Advocate Pardiwala, who was appearing in this matter. Now this here this one girl of 20 years, she was in physical relation with one person. Now here it was for the family. After she became pregnant with that person, it was very difficult because she was an unwed mother. Now they wanted to abort the child. Because they were not very educated, they took in a private dispensary, and this accused was actually not competent to do the abortion. Now here it was really difficult for them, and somehow he tried to abort the child, but he was unsuccessful, and this lady, victim lady, was unable to even take any she was so much in the pain that she has to taken to the government hospital. Now when she was taken to the government hospital, the government hospital came to know that this is a case where she is an unwed mother, and her fetus was killed in her womb, and it was not done properly. Now this abortion, even the miscarriage or the abortion was done with her permission, it was not done properly. So police came into the picture. She was indoor patient for 22 days here, and she was treated. So she was actually very injured. Now police came to the scene, and a case was registered under section 313 of the CRPC. Now section 312 and 313, Indian Penal Code, both these sections were applied. Now the advocate Pardiwala, who appeared in this matter, that said that though he was punished by the session judge. See, mind it, this is a session tribal matter. Now, uh, he was convicted, here when the matter came before the High Court, the advocate Pardiwala said that there is a difference between section 312 and 313. Here the fetus was not quick to the life. See, when we see the section 312 and 313, there is what. See, I will again share this definition, which is very important to understand here. Section 313 and 312. The word used is that if such miscarriage be not caused in good faith for the purpose of saving the life of a woman, be punished with imprisonment either discretion for a term which may extend to 3 years, or with fine, or with both, and if a woman be quick with the child. Now here the meaning of the be quick with the child, that if the child has actually developed all the parts of the body, and after 4 months it is actually develops movement in the your womb. Now what happens, that if the child, here the fetus was only 2 months old, so the advocate Pardiwala very rightly submitted before the court that the child was just not very quick to day, so the punishment was reduced. So it is very important that whenever we run the trial, we should know that what is the punishment and what are the ingredients of the section. If this here the word was quick to the child, quick to the child means the 4 months have passed. That's why the law does not allow, mostly after 20 weeks. Now there are judgment which says after in the 24 months, 24 weeks also, the pregnancy can be terminated with the permission of the court. Sometimes it is 25th and 26th also in some of the judgments, but very rarely it is. Mostly it is between 20 to 24, because there is a risk to that woman itself who goes for the abortion of the child. Now here when we said it is quick with the child, that she is below, if she is not quick, that is below 4 months, then the punishment is less. So here it is of section 312 and 313. The basic difference we have to understand this. She is quick with the child, not quick with the child. This is what has been submitted by Advocate Pardiwala, and this one point is worth reading this judgment of Imtiaz Ali Sheikh. It is of 2008. Now, next we go to the another aspect which is very important here, to go to the PCPNDT Act. Now, PCPNDT name itself is very long, but normally we call it PNDT Act. That is Preconception and Prenatal Diagnostic Techniques, and in the bracket Prohibition of Sex Selection Act. Now, this act, though of the recent time, see, when the technology developed, it was like sonography used to be done of a pregnant woman. It was only to find out whether there is any deformity with the fetus, or there is any abnormalities, or to detect the genetic any abnormalities. If there is no genetic default or any disease which can be found out from the sonography, then it is possible that the woman can go for the abortion. This was the reason this sonography and this technology was brought into the brought up. But here, what happens when this preconception and prenatal diagnostic technique, this act was brought before, there was so many diagnostic center, and whenever the there was there is a female fetus in the woman's womb, the family used to tell that abort the child, we do not want. Now there are so many like mushrooming of these diagnostic centers which were taking huge money from the people, and there was because of this, the sex ratio of the female was getting down in the country. Somewhere in some parts of the country, it was in the village part, mostly in the rural area. If it is for boy, it is 1000. For the female, it was 800, 900. And whenever it goes below 900, there was a possibility of the biggest disaster, because naturally the country or the world or the people or civilized society is not balanced. Now, in such situation, what is very important here, that is to maintain this balance. It is very important that if there is a birth of the, she may be a female child or male child, it is the nature which is bringing the to the birth. Now we should not interfere in the nature's cycle. Now, because of this, there were a lot of ratios in the country. There was a lot of society, I will say many NGOs coming forward, and when they came forward, they said that this shouldn't be done, and this diagnosis center, there should be some law. And when this law was brought, still there was uh, lot of this doctors or the diagnosis center which were taking huge money, and they were giving the information that is the fetus is a boy or fetus is a girl. Now this was very difficult, and for the government also and the country as a whole also, because the ratio of the female fetus was going female child was going down in the whole country, and this will not balance the society. Now, to curb on this, there were many judgments, and in 2014 and 15, 16, there were many orders from the Supreme Court, from the bench of Justice Deepak Mishra, which has brought out a judgment when a lot of guidelines were given, and they said that the all these diagnostic center, if they are doing this, they will be punished, and there will be curb brought on this. All the state governments, through with the help of the chief justice of the respective state, that is of the high courts, will form a committee of the 3 judges at the high court level, and all the offenses of the female fetus, miscarriage or the abortion will be reported, and these cases will be on the fast track. This was how important it was. This judgment, I would request all of you to read. Voluntary Health Association of Punjab versus Union of India. From 2014 to 2016, there are many orders on the uploaded on the web portals. You can see the indiankanun.com also. We'll find so many judgments. So this is also one part when we say about reading about the section 312 and 313 of the Indian Penal Code. Now we'll go to other judgments. That is one from the Delhi High Court I would refer. Mohit Gupta, that was the state of Delhi. Now there is a possibility that whenever there is a complaint under section 498A, possibility that a person, the lady who is a victim, she may complain that she was forced for abortion, or she has been beaten black and blue to the extent that her child has been aborted. Now in this matter, in Mohit Gupta's matter, this was a 498 matrimonial dispute. There was a complaint against all the in-laws. Here, when the matter came up before the court, see, if it is section 313, it will be tried by the session court. Now, what happens when this matter came before the court? The defense taken by them that there is a material that she herself has gone for the abortion, and there was signature, her signature and her mother's signature on the form for giving consent for abortion. But this was not accepted by the informant, that is the complainant lady, and she said that she was forced to sign that form, and she had no reason to she had no reason even to abort her child, because she herself was 5 months pregnant. Now here, see, she was very quick to the child, and if she goes for abortion, uh, if she is 5 months pregnant, it is actually not possible for any doctor, unless two opinions are taken of the two general practitioners, that in good faith or for some good reason, the child can be aborted. So court did not accept the plea of the accused, and they said that if she was 5 months pregnant, she had no reason to abort because her own life was in jeopardy. It was very risky for her also to get abort. So this was held by the court that let the evidence be led, and then only this section, even though there was her signature on the form, it cannot be accepted that she has signed without any force from anybody. So there was enough evidence on the part of the complainant that the accused can be proceeded under section 313 also. So it becomes a session triable. See, 498A is a magistrate tribal, while the section 313 is a session tribal. So if there are few sections which are magistrate tribal, and there is one section which is session tribal, the matter will go to session court, which is actually very serious from the accused angle for running the trial. So next we go to the Harjinder Kaur judgment. This is from Supreme Court. Now this Harjinder Kaur versus State of Jharkhand, it is of 2001. Now this is again a matrimonial dispute. Normally you will find the matrimonial dispute or rape matters here. Now in this matter, section 490 and 313 was applied. As usual, 498 will be triable by the magistrate court and 313 by the session tribal. So matter will go to session tribal. But when this matter came before the charge sheet was filed, the doctor who has performed the abortion, she was not called she was not sent for the trial. So she was not made accused. So on this point, the accused made an application for deleting the section 313. So section 313 was deleted, and the matter charge sheet was filed before the magistrate court. Now this lady, the complainant lady, preferred a criminal revision before the High Court, where she was saying that the accused should be tried under section 313 of the Indian Penal Code also, because they were the reason for aborting the child. But now when the matter came before but High Court said you have not challenged the basic order, because why the doctor was not made an accused. Also, then when the matter was section 313 was deleted on the application of accused, even that order was not challenged. This criminal revision before the High Court fell, matter came before the Supreme Court. Supreme Court also said that as you have not challenged the basic orders of that the doctor who was not made an accused and was not sent for trial, also the accused when made an application on deleting charge 313 on the basis of that doctor was not made an accused. So all these both these orders were not challenged, so you cannot challenge the final order. Now here Supreme Court made one more objection in this matter, that if there is during the evidence before the magistrate court, if there is some evidence which comes forth which says that her child was aborted, even the doctor and the all the accused can be added with the section 313 of the Indian Penal Code. So it is very important that whenever charge is framed, you should see under what charges the charge sheet frame. Also, whenever charge sheet is filed, always read the there is a word note on the charge sheet. Under final charge sheet, you have to read the final challan is filed under what sections. There is a possibility that some sections are deleted. Sometimes some sections are added. So it is very important whenever we go for we run the trial, we see that the final challan, that is charge sheet, is filed under what section. If we do not know what sections, because there is a possibility some sections are added, some sections are deleted. Here the same thing happened in this matter. She was not aware, the doctor was not even made an accused when the charge sheet was filed. Also on the basis of that, the accused took an advantage of the same and they got their names, they got the section 313 deleted against them. Next is another very important judgment of Hasi Mohan Burman. This is also from the Supreme Court. Now, in this matter, he was in a physical relationship with one lady. Now, what happened that because of the physical relationship, she got pregnant, and obviously he did not want to marry, so he was forcing her to go for abortion, and she was not ready. He somehow took her to a pharmacist friend and got her injected, and she became unconscious, and her child was aborted. Later, an FIR was filed against this person, and also the pharmacist. Now, this matter came before before the session court has convicted both the pharmacist and all this person who was in physical relationship with the first informant. Even High Court upheld the conviction given by the Session Court. When this matter came before the Supreme Court, in all these years, this complainant and the main accused, because of whom physical relations she was pregnant, they both got married. Now, here when we see this judgment, the High Court says that in this kind of matters, even if there is a compromise between the parties, the matter being very serious, session tribal, there is a punishment of life imprisonment. Now, in this kind of matters, even though the complainant and accused have compromised, it cannot be brought under the section 320 of the CRPC where compromise is allowed. Now, in this serious kind of rape, murder cases, it is not possible. But here, it was very clear that the complainant and accused both have married each other and they were living a peaceful life. Now, because if he is convicted, there is a possibility that this lady is also going to suffer. So, Supreme Court said that whatever punishment is undergone, that is of the 10 months till now, that is the punishment which will be upheld, and the rest of the punishment is reduced to whatever punishment he has undergone. And there was no more punishment awarded to him. It was not even increased. It was reduced to whatever is undergone. Now, this is the one reason we should read this judgment, which is very important, that what kind of matters there is a compromise allowed, and if it is allowed, in what situation, if it is not allowed legally, under what situation, what we can pray. Fortunately, here the court reduced the punishment of this Hasi Burman to the already this conviction period he has undergone. So this is how he got saved. So this is the reason we should read. There is a possibility we find there is no defense is available sometimes. There is a possibility that we do not even have the any point on which we can go to the Supreme Court. But here, as both were married, though legally it is not a point which can be argued before the Supreme Court, but it can brought in the knowledge of the court that they are married couple now. There will be no, actually this girl will be suffering if the husband goes into the jail. And this is how the Supreme Court reduced the punishment to the already undergone, whatever he has undergone, the Hasi Burman. So the reading of judgments always help. This is what I have been telling all of you. So thank you.